9/3 Lordship.
9th April. Huh?
Make up
March.
March 9th. 23 and 24 Lordship. Much.
I beg to mention item number 46 Lordship. I have taken consent from the other side. The 46 Lordship. Hearing matter. It may come after 2 weeks Lordship.
Prayer of learned counsel for the appellant and with the consent of the other side list the matters on give a date.
And another item. I am paying on behalf of L. Sharma. And another item is Lordship 49. In this case, Lordship, I have filed objection. So I may be allowed to bring that record, Lordship, requisition, Lordship.
Analogous with which?
Item number 49.
You have filed?
I have filed objection, Lordship.
Which is not on record as yet.
Record has not come, so I may be allowed.
My lord, I pray for adjournment of item number 37. I have also taken the consent of opposition's advocate.
All right, same order. Site list on.
My lord, after 4 weeks.
All right.
I love that.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 27 Lordship. Lordship, here after taking service and upon the appearance of the office note, we came to know that respondent 2 had died, expired. So we will find the appropriate substitution applications in due course of time to plead the legal rights of respondent number 2. So we pray for some more time to.
Item number?
Item number 27.
Item number 27, it is submitted on behalf of the appellant that the respondent number 2 has expired and accordingly seeks time to submit substitution petition. Prayer is allowed. List again on.
4 weeks time, Lordship. To
Yes.
ascertain the names of the legal rights of the respondent number 2. After second or any date, Lordship. 6 April. Must oblige.
May I please, Your Lordship? With the consent of the other side, Lordship, I beg to mention item number 44. Lordship, may kindly give me 2 weeks, my lord.
All right, same order.
Your Lordship, I am for respondent number 1. I have one prayer, Your Lordship. My name may be reflected in the cause list.
In the name of Mr. The respondent column of the cause list. It.
Oblige, madam.
Please, Your Lordship. Your Lordship, I beg to mention for listing of a regular 1st April, Your Lordship. It's 2012 matter, Your Lordship. Last it was listed on 6/10/2023.
Senior bench is there.
And 43 in the orders category is an application for early hearing which we had listed. Since the early hearing was not being listed, we had mentioned it before the senior bench, Milord, and we were given a date in the RSA itself. So we do not wish to press this.
Item 43. The submission of Mr.
A. Fukon.
A. Fukon, learned counsel for the applicant. Only the IA.
And IA for this early hearing of the RSA. In the RSA itself, we managed to get a date.
RSA 50.
Yes.
The IA, instant IA is dismissed as not pressed.
Raised.
May it please your lordship, with the consent of the petitioner, I beg to mention item number 34. Kindly this matter may be adjourned for today. Your lordship may fix any date as the lordship deems fit.
34.
34.
You are for the?
We are for the petitioner.
34. When?
Any date lordship may deems fit.
Quick, sir. Will you?
Oblige, my lord.
May I please, your lordship? Let I beg to mention item number 2020, my lord.
Hmm.
Service upon the respondent number 6 has not been completed. I have seen the record, my lord. But let the matter be after
Item?
2020, my lord.
Item 20. Just again, no.
Highly obliged.
Item 1.
Please, your lordship.
Yes.
Lordship, in this case, TCR is required to be called.
Proceeded case.
All right. Scan copy of TCR along with chart with.
Kindly a date may be fixed.
Kindly pass over for timing, as my senior is not well. If possible, kindly fix at 2 p.m.
We have not seen 2 p.m.
This is of 2018. My execution is pending, so kindly.
What do you mean he's not feeling well? He'll be okay by 2 p.m.
Yes, Lord, my lord.
Let him come at 12 p.m. 12 a.m.
Hmm.
Noon.
Item 3.
Your Lordship. Your Lordship, the leading counsel, Mr. Abir Fukan, is on legs in another court. Can it be passed over for timing, Your Lordship?
My lord, this has been wrongly listed for admission hearing because it is already being admitted. It can be posted for hearing.
All right. Submitted that the matter has been wrongly listed for admission as it has already been admitted. Hence, list the matter for hearing on immediate.
After 7th of March, any day.
Oblige.
Item 4.
May please, Your Lordship.
Well, this revision is directed against the order dated 14/7/2017, while it passed in Miss Appeal number 5 of 2015 by the District and Session Judge Kamrup, my lord. Now, what had happened, my lord? A notice under Section 4 was issued to the respondents. And even after receipt of notice, since he had not appeared, my lord, the notice under Section 5 was issued. On receiving the notice, my lord, the respondent, they approached the session court and filed this Miss Appeal. And the Honorable Judge, my lord, has decided the appeal in his favor purely on assumptions, my lord.
Where is the order?
The order is at, my lord, page 42. Well, he has decided the appeal on 2 grounds, stating that the notice did not properly identify the land. And also he has relied on some documents filed by the circle officer on a report saying that since a settlement was given to some other persons, so this must be a government land and this is not a railway land. Basically, these are the 2 points on which the appeal was decided. In fact, my lord, the revenue was also a party with that, my lord. He could have easily called for the records because the railway, my lord, what happened? They only are given the revenue maps. where the signature of both the parties are there. And the railway, my lord, they make some site plans, and on that basis, they have been doing their work, my lord, for since 1917, my lord, since the land was given to them. So they were using the old DUG numbers. And they said that the present DUG number, that is 193, that is a government land and it's not a railway land. So easily, my lord, the record could have been called and verified, because that was the main issue, my lord.
Where is the railway?
My lord. Well, I'm for the railways, my lord.
Hmm?
The
You are
railways
for the railway. What about
my lord, the notice was served. It was assumed that notice had been served on the respondent number 1, and respondent number 2, my lord, is the SC revenue. I have personally served copies, my lord. It is there. Miss Priti Gogoi, she received the notice, my lord, and it is reflected also SC revenue.
so everything is complete? Let us fix it for hearing then.
But it may admit it and fix it for hearing, my lord. In the meantime, my lord, the direction will be given to the SC revenue, my lord, to produce the records, my lord. Unless and until, my lord, the records are produced, it would be very difficult.
Heard Mr. A. Borkotoki, learned counsel for the appellant.
Petitioner, my lord.
This is a
Revision petition, my
revision
lord.
for the petitioner. Pending counsel revenue is not present. Respondent number 1 do served is represented. Peruse the impugned order. Since the TCR scan copy of the TCR has already been received, the case is admitted for hearing. Standing counsel revenue is to produce the connected records at the time of hearing. Is the matter on
Immediate, my lord. Much obliged, my lord.
Please, your lordship. My lord, this is a defendant petitioner, my lord. What happened in this case, my lord? Plaintiff filed a suit for right title interest and cancellation of two sale deed. Two sale deed, my lord. That's the lordship going to, my lord. Page 18, my lord. Why I just wanted to show the pairs, my lord. Pair of the plaintiff. Page 18, your lordship, kindly see. Page 18, my lord. This is the pair, my lord.
Yes.
Two sale deed. My lord, they have not mentioned the amount, but that sale deed is, my lord, one is, my lord, more than 5 lakhs. One is more than 3 lakhs. So one is, my lord, 6 lakhs, 48,000. So, my lord, then thereafter, my lord, that defendant file an application for, my lord, application under Order 7, Rule 11 for rejection of the plaint on the ground of pecuniary jurisdiction. But that was rejected. Against that, I came before this honorable court. My lord, now, my lord, I want to place, probably in the meantime, my lord, issues were framed. If issues were framed on that particular point also, then it will be covered, I think. So that's why I want to place the issues, my lord. I have not received the issues yet till now, my lord. So if your lordship, my lord, I have just now I came to know the issues were framed. If issues, my lord, one of the issues is that whether it is proper value is there or not, my lord, then it will be covered up. So give me some time, I will place the issues, my lord. Because it admittedly nowadays, my lord, 5 lakhs is the civil judge junior value is 5 lakhs. But here, my lord, admittedly, my lord, sale deed is, my lord, more than 6 lakhs 48,000. But they have not mentioned the amount, my lord. So that, my lord, if issues were framed, then I can, my lord, is it the matter, then that way also.
All right. TJ Mohanto, learned counsel for the petitioner, submits that the issues have been framed in the connected title suit and hence prays for some time to obtain instructions. Accordingly, list the matter again on so and so. So and so appears for the respondent.
Yeah, prayer lordship that date maybe.
Yeah.
My lord, no problem.
But can it be within this month, lordship?
Already
Last part of March, lordship, on 26, 27, any day.
31st.
31st.
Enough.
31st. Fine. Biplab.
Oblige.
Item 6 and 7.
Hi, Prijal. Well, item number 6 and 7 are connected matters, and my friend is appearing for respond number 1. And I'm appearing in 7, item number 7. 7 to the by 7. My lord, the impugn order is at page 65, my lord. So before going into the impugn order, my lord, if your lordship kindly comes to order dated 1/10/2024 passed by this honorable court in the civil division, everything will be clear, my lord.
Yes. Yes.
Lord, with my limited knowledge, I have tried my level best to find out whether under order 11, this kind of order can be passed. And I have found, my lord, it's not. Order 11, rule 14, my lord, speaks of production of document. Lord, if your lordship kindly comes to their petition, which is at page 56, annexure 6. The prayer portion is at 59, my lord. Internal page 4. Admit this petition and be pleased to pass order directing the respondent to submit all the information.
You're on page?
Page 59, my lord. Internal page 4, prayer portion, my lord. This was the petition filed by my learned friend at trial court, praying for a direction to the defendant opposite party to submit all the information. But CPC does not provide for information, my lord. Order 11, Rule 14 speaks of production of document, my lord. I have gone through the Order 11, my lord, and there is no provision as such, my lord. And this is the reason, my lord, the question arose on 1st of October, my lord, the order your lordship has seen, whether the trial court passed rightly or wrongly. Now, your lordship will kindly come to page 65 now, the impugn order. Page 70 will be relevant, my lord. Last paragraph. Your lordship has come to page 70. It is seen that the plaintiff has filed this suit challenging so and so. In view of the fact that the defendant number 1 so and so, develop so and so, have sold a constructed plate to the prospective buyer, the prayer for the plaintiff directing the defendant to furnish the names of the prospective buyer is found to be justified. Under what provision of law, my lord? That is the question. That is the reason I am here before your lordship. Whether the trial court has power to pass such order. Reply to my revision petition, my learned friend has filed an affidavit. Eleventh of February, 2020.
Robots, I don't get it.
There is an affidavit I have received.
27/9/24.
27/9? No, I received for 11 February 2025. Well, anyway, there is an affidavit filed by my friend, my lord. Your lordship will come to page 80, my lord. He skipped to answer the question of law, my lord. I am reading the 13th line, my lord. The learned trial court passed the said order, considering all pros and cons of the matter and considering the necessity to do complete justice in accordance with law. My lord, what provision of law, my lord, let my learned friend satisfied?
Yes.
My lord, without going into the fact of the case.
Yes, respondent.
Lordship, exponent number 1.
My friend is appearing for performer respondent number 2 and 3 in 7, and 7 he is appearing for the petitioner. 6.
Lordship, our main difficulty that is being faced in this matter, Lordship, is that we want inclusion of our name in the partnership deed, Lordship, as well as for entering our name into the assets and liabilities and everything, Lordship, into the partnership fund, Lordship. So what happened? We have filed a case on the specific schedule of the property. Thereafter, we have given a intimation to the concerned revenue authorities, to the circle officer, as well as to the sub-register office, that a litigation is pending with respect to this particular plot of land or this particular project, Lordship. We have given that intimation or objection in 2019, Lordship. Subsequently, in 2023, all the flats has been sold, Lordship. So my humble submission is, Lordship, Section 52 of the Transfer of Property Act, Lordship, that say prohibits ki when there is a litigation is pending with respect to properties, Lordship, till disposal of the suit, the same may not be done, Lordship. So what happened, Lordship? If at all I may be allowed entry by the trial court or my suit is decreed, Lordship, in my favor, then I will simply get a paper decree, Lordship, which cannot be executed. We have tried our level best to procure the sale deeds from the concerned authorities, but we have failed, Lordship. So that's why we have filed this instant application, Lordship. Let them declare. Because otherwise, Lordship, if we get a decree in our favor, that will be a paper decree, Lordship. We won't be able to execute. And even the proper flats have been sold and subsequently resold also in 2024 and 25, Lordship, in which my interests are at stake. Finding no other alternative, Lordship, we have filed this application before the trial court. So Section 52 specifically bars transfer of property when litigation is pending. How can, when the specific schedule of the property is under challenge before the trial court, how can
We'll come to that when that issue comes up for consideration. But at present, we are only on this limited aspect as to under what provision of law this order has been passed. You are required to address that point first.
Lordship, give me some time, grant me some time, Lordship. I will address the Lordship on this issue.
So what were you doing all this time? You want some time?
Well, I have no objection, my lord. The only thing, my lord, what learned friend is saying is all about facts of the case. Since who prevented my learned friend to appear and obtain an injunction since 2019, my lord? There is no injunction as of this date. And now he is saying by filing this petition, he wants to restrain us. Right, my lord, let them take time. Look,
We heard
I mean, it does.
counsel for the petitioner. The heard learned counsel for the respondent who.
Take a copy.
Oh, respondent number
1 in
One.
both the matters.
6, further time to, let's say, obtain instructions. Hence lays the matter again on.
এটা ফিক্স কৰি দিয়ক 18 নিদিব 17 18 নাই তাৰ পিছত দিয়ক
বন্ধ আছে তো 18 কি মাৰ্চ 18 মাৰ্চ দিব পাৰে
17 18 মাৰ্চ মই নাথাকো কহিমা প্লিজ
20
20
Both 6 and 7.
12. There is an interim order that may be called.
In which
Well, 110-24 in both the cases.
interim order passed earlier to continue till the next date of listing.
Public.
obligation
Yeah, I can make.
In this case, my lord, I have filed one additional affidavit, my lord, that your lordship will find that, my lord, flag A, my lord. Page 106. Page 106. My lord, this is the detailed grounds of arrest to the accused person, my lord. My lord, it was not served to us, my lord, as because there is no acknowledgement, my lord. There are two petitioners, my lord, page 106 and page 108, my lord.
So signature was not there.
Signature was not there, my lord. And my lord, this is with regard to 47, my lord, and with regard to 48, my lord, although the WT message has been sent, my lord, but it was not served upon us, my lord.
Where is the 47?
Page 147, my lord. Page 105, my lord. This is the notice to inform grounds of arrest, my lord. First, your lordship will see, my lord, particulars of the arrested person. Second, below, my lord, details of the case, my lord. Now, grounds has not been stated here. The next page 106, my lord, the grounds have been arrayed, my lord, where there is no signature of the accused, my lord. My submission will be, my lord, it was not served upon us, my lord.
This is a continuous page, I think.
Continuous page, but first page, your lordship will find, my lord, particulars of the arrested person and the details of the case. And thirdly, my lord, the next page, my lord, it is the detailed grounds of arrest specific to the person arrested, my lord. And below, your lordship will see signature of the accused, arrested accused. No signature, my lord.
But signature is there in the first page.
First page is with regard to the particulars of the arrested person and details of the case. Grounds, my lord, no signature, my lord.
This is not a otherwise a statutory format, is it? This one separately grounds.
My lord, today one, my lord, case, my lord, Keshi Reddy's case, my lord. In paragraph 35 of that case, my lord, it was specifically stated what should be the grounds, my lord. What should be the grounds?
No, that we understand, but now the question is whether this is to be considered as a whole.
No, my lord.
Or that is
Because,
why
my
I'm
lord,
asking this format, is it?
so far, page 105 is concerned, my lord, only the particulars of the arrested person and details of the case.
No, suppose
Where-
both are, suppose this is one single document
My lord.
and it is served to you.
The second
Your
page-
signature is obtained in one place.
No, my lord, then second page, my lord, then why they have written, my lord, signature of the accused person? Then why he has written that part, my lord?
Yes, PP, what do you say to this?
So this is a continuation page, Lordship. Lordship, first page, Lordship, his signature was put on. In second page, Lordship, it was not put. But Lordship, they whether it was sent that I was trying to look into that whether it was sent to the learned court below at that time it was there or not, Lordship. Because Lordship, once the ground of first format is there, second part is also it will be served. Otherwise, there is no why it would not be served to them, him, Lordship. And apart from that, Lordship, regarding that, Lordship, this question was brought now only. Earlier, two petitions has been rejected. Two times it was that at that time it was not rejected. They did not provide with the grounds of arrest, Lordship. Now this question comes, Lordship, when there is no any other grounds. Now they have taken this plea that, Lordship, only putting in the signature in a second page. That is whether it is required or not, whether it is mandatory, not whether somehow he is demonstrably prejudiced or not, Lordship. That into that part, Lordship will look into, Lordship. Because, Lordship, while considering the earlier repetition, deciding the earlier repetition, Lordship has also observed that a perusal of the record would show that section 47 of the BNSS have been duly complied with as far as provided to of information regarding the ground of arrest. Only because that signature is not put there in lordship. If it is so much technical, we will go, then we have to see lordship that lordship. Earlier, they did not make that application. They did not take took their ground that 47 not complied with. 2 times they have taken ground that 48 is not complied with. Third time they are again come out that 47 is not complied. So whether they are demonstratively prejudiced or not, lordship, because lordship, immediately after receipt of this, he is being arrested. Within 2 days, the council appeared for him, Lord. So lordship had, earlier to the rejection order, lordship has discussed everything, lordship. So lordship, at least says again that plea can be reviewed or can be looked into, lordship. Lordship will also look into that part, lordship. Only putting that signature in the second page, because this is, as lordship has put that question, whether this is a statutory format or not. This is not a statutory format, lordship. This format, everyone makes it in different way. So this is not a statutory format. That if it is a statutory format, then his signature must be there as in the arrest memo, lordship. But it is a continuation page. In second page, if it is not there, only that his signature is not there in the second page, therefore he is entitled for bail.
Yes.
And earlier also, lordship, they did not took that ground, lordship. 47, 2 times they have filed application. They did not took that class. Even lordship, in first application, first rejection, lordship has observed that part, lordship. That 47 is complied with. Even in second part, they did not took that plea, lordship. They no, this is as lordship has observed, but as per our record, it was not furnished. And the same council is also today before you, lordship. It is not that there's another council is before. Same council. Same council is at the time also, now also, lordship. So lordship, whether that ground is taken, a bail order can be reviewed without any new ground or fresh ground, lordship. Article section 4362, sorry, 403 is also there, lordship. Lordship.
All right, we have now understood the question that is to be answered. We'll deliver it on that.
My lord, the problem arose, my lord, because, my lord, I'm not blaming anyone, my lord, to be fair enough, my lord. Page 43, my lord, there's an order passed by your lordship, my lord. There, my lord, the submission was there, my lord. Par contra, the learned APP had submitted, the petitioner have been made full aware of the grounds of the arrest, as would be apparent from the notice under section 47. So the record was not perused, my lord. And so far 48 is concerned, my lord.
No, even if the record was perused, the signature would have been seen on the first page.
Yes, that's why, my lord. And moreover, my lord, so far section 48 is concerned, my lord, it was sent to the WT message, my lord. Now prejudice, my lord, that part, my lord, Darshan's case, my lord. Now, my lord, judgment of the Supreme Court, my lord, in Ahmed Mansoor, my lord. Can I hand over the copy, my lord? Sir?
Yes.
Page 6, my lord, the paragraph 3, my lord. My lord, it says, my lord, although there is a Darshan's case, my lord, but this court emphasized on the Bihan Kumar case. And Sri Darshan's case is a different footing, my lord. That was a cancellation of bail, my lord.
Lordship passed
No,
this
let me finish.
bail order, automatically will go to the Supreme Court for cancellation. In Supreme Court, maximum cases will be cancellation of bail withdrawal, lordship. This is a different footing, lordship. Same footing, lordship.
But the Supreme Court itself has said it's a different thing for cancellation. So
Pass the record. And one more.
If we are to follow Ahmed Mansoor,
my lord,
we will follow it in full.
Yes. And my lord, our division bench judgment, my lord. Our division bench judgment, my lord.
We'll follow it in full and include the following lines in Ahmed Mansoor. However, while setting aside the order passed by the High Court and consequently setting aside the order of arrest and remand, we would only say that liberty is granted to the respondents to take recourse to law to arrest if a case is made out.
Let them do, man.
So, Pyrrhic victory.
Okay.
Even if it is allowed, moment you come out,
But one judgment, our division bench judgment, she has misplaced it. I will submit to the franchise. I'm obliged.
in fact, in this last case, not me, Sir Rajesh,
Me.
Rajesh, they're also going to say he can again be arrested if it is
Yes.
released on a technicality.
But I'll place that judgment.
That is over what? Which place judgment you are placing?
My lord, the division bench judgment, my lord, where it says, Lordship is aware, my lord.
That is okay.
My lord, that we will follow the Vihan Kumar judgment. I'm obliged.
Next time, chamber.
Item 9, we have not received the CD lordship.
But the save করে থব পারলাম কিছু সাইলাম ভালো
Several times update CD has been several times call forward.
Last month maybe even lordship.
Which station is this?
Nagaon. Nagaon? Then requisitions.
Had learned counsel for the petitioner. It appears that despite several reminders, the IO has failed to furnish the CD. There is one that again directed to and the CD by the next date fixed. In the meantime, it is provided that no coercive action shall be taken against the petitioner.
Earlier rejected petition also.
Yes, but look at the conduct.
Right.
That might maybe recorded because lordship so that you can also get some action lordship because of their as they are not sending it repeatedly lordship.
Yes, yes, it's in view of the fact that the IO has failed to produce the CD on several occasions, no coercive action shall be taken against the petitioner.
Data reason. How degraded in this how degraded on 16 lordship.
Item 10.
CD was called for, my lord.
Here also we have not received the CD lordship. He is an interim lordship.
It may be continued.
All right, she did not receive. Interim. Interim is there.
Lordship.
For you to continue till the next date of listing.
10-11.
Here we have received the CD, but it is not updated lordship. Since that it is updated prior to the last eviction also.
Lordship, here in this case, the matter pertains to some transfer of the amount. And on the last occasion also, Lordship, I made a mention with regard to the fact the petitioner is intending to return the amount. Now, this taking into account this aspect of the matter, Lordship, this Honorable Court may consider the interim prayer of the petitioner. On the last occasion also, I made a prayer with regard to that. If I'm arrested at this stage, I'll not be in a position to return the amount because whatever is the confusion was there, the amount was transferred to the account of some relative of the petitioner, and he is ready and he has already given.
This is the first date only.
Some protection may be given, Lordship, at this stage.
CD is called for has not been received.
The CD we have received, it is not updated. We have to
The CD, although the learned additional PP submits that although the CD has been received, it is not updated since the date of the last order of rejection of the prior bail application of the present petitioner. Hence, IO is directed to submit updated CD by the next date fixed. In case of full stop, in case of failure, the prayer for interim protection shall be considered.
Can I shortly be given?
on 9.
How about this one?
I have on behalf of respondent matter in claimant matter. Claimant, I have filed this, already filed this affidavit, my lord, affidavit in opposition. The order is correct order, my lord. They challenge only for delay the technique of the payment the awarded amount, my lord. That is the, they have paid for content, if in case is admit, my lord, to 57% awarded amount may be deposited, my lord. Because the claimant is in his childhood, my lord, his father was expired. And when he claimant is reading in class 8, my lord, then his mother was expired in road accident. And no any financial help, my lord, in his family, my lord. Claimant is suffer for very financial crunch, my lord. He's a study in college, my lord, at now. But when the road accident was occurred, my lord, he is class 8 student. And when he was born, after born, his father was expired, my lord. And no any family person is caretake his child, my lord. So kindly, honorable court, maybe deposit the 50% awarded amount, my lord. It is very needful for the claimant, my lord.
You have not deposited.
Lordship will just come for the admission today, Lordship. This case, Lordship, there is no dependency factor. The claimant is
The deposit, when is the deposit to be made? At the time of filing?
At the time of filing, my lord.
at the time of filing statutory deposit 25,000.
25, that is then not acceptable, my lord, because claimant is he lost his father in at the time of born, my lord. And when he studied in class 8, my lord, that his mother was expired in road accident, my lord. And now it is.
We cannot pass a direction contrary to the statute.
Statutory.
Statute says 50% of the deposit or 25,000, whichever is less.
50% is 20. It is a not as per order, my lord. Now in present, the Supreme Court direction, my lord, they have filed is appeal is admitted to 50% awarded amount may be deposited, my lord.
See, it is my appeal. I am not saying anything. He is submitting, Lordship. This case, Lordship, there was no dependency factor, number one. And number two is that regarding deduction, there was one dependent, the current member ought to have deducted 50% instead of 50%, deducted 1/3. Lordship, my application, the appeal made, we will deposit 25% of the awarded amount.
50%, man.
25% of the awarded amount, because they will entitle the under the.
You are ready to deposit. You are ready to deposit.
25% of the awarded amount.
25.
You have.
25% of the awarded amount we will deposit.
No, my lord, 50%, my lord, because
They will
case is
not have
pending
that-
from 2018, my
You
lord.
should be happy they are willing to deposit 25. Otherwise, statutorily also they are not required. Is that not the provision?
Lordship. At the time of the filing appeal, we have to deposit to 25,000. Accordingly, we have deposited.
Is what 25,000 because the statute says 25,000 or
Yes.
50% of awarded amount, whichever is less.
Yes.
That is why we have deposited
Yes.
25,000.
25,000.
Now you are
Now
willing to
we will
deposit
deposit
25%.
25% of the awarded amount.
Yes. So you should be happy.
And it may be on the
Hard learned
condition of.
counsel for the appellant and learned counsel for the respondent. The appeal is admitted for hearing. Call for the PCR. It is submitted on behalf of the appellant insurance company that the insurance company shall deposit 25% of the awarded amount within a period of
6 weeks.
In a period of 6 weeks from today.
Before the registry of this.
Before the registry of this court.
Respondent may be allowed to
So
withdraw
in
the
the
statement.
event of such deposit, the respondent is allowed to Withdraw the same.
With statutory amount, my lord.
Statutory accounts is not allowed to withdraw.
All right. This is the matter again, ma'am. For hearing.
The date may be fixed. my lord.
LCR.
Yes, so for, let it come on order once.
I live. Third April. Okay.
Lordship,
Yes.
I think the concurrent finding, Lordship. Present second table, Lordship, I have framed a substantial question of law that is at page 4, Lordship. Lordship.
Where? Page 4.
Page 4.
With so many substantial questions of law. What was the case about?
Lordship, this is about appellant purchased the plot of land in the year 1952 by registered sale deed. But Lordship, during trial, while the evidence was laid by the appellant, sale deed were not exhibited by the plaintiffs. Registered sale deed has not been exhibited before the trial court. Only a Lordship unregistered deed was exhibited. And other witness also, Lordship supported the case of the plaintiff that land was purchased by him, land was mutated in his favor, and he appellant were in possession for long period. Defendant side appeared and contested.
So if you admit that the terms of the transferor contained in a document, written document, that is the registered sale deed, how can you lead oral evidence?
Oral,
Lead by section 91 Evidence Act without producing the sale deed.
Lordship,
Secondly, as you say, if you have produced the unregistered sale deed, despite the registered sale deed being present, you fall foul of the rule of best evidence there. So what is the question of law to be decided here?
other question is there, Lordship. Defendant side only plea was that it is barred under section chapter 10 of the Lordship Assam Land and Revenue Regulation. That was their plea. No evidence was laid by them. Land was mutated in the name of the Lordship present appellant.
If it is barred by some provision of law, what evidence is required to be laid?
But that is amended in the year 1964 by the amendment that was incorporated provision.
Land was purchased in the year 1952. That aspect may be.
What is the finding of the court on this point?
Barnett, Court Lordship. The issue number, Lordship, 3, Lordship. Decided. Lordship, kindly have a look at it, page 31, down below. Actual. Regarding the applicability of the provision of chapter 10 of the regulation, the Honorable Gauhati High Court in Soneswar Bosmatari versus Assam Board of Revenue and others, 1992, the legislature, which was quoted, the legislature in its wisdom has created an embargo by specifically prohibiting transfer and the alienation of land within that belt area. The legislature has delineated its will by introducing a non-obstainty clause in subsection 2 to section 162 of the regulation. The Assam Land and Revenue Regulation Amendment Act 1990, as indicated earlier, further fortifies its will not to permit unfair transfer land by landholders in a belt or a block to any person not belonging to the class of people notified under section 160 of the regulation, or to any person who is not a permanent resident of that belt or land, even in case of a person who is a permanent resident in that belt. Granting the of permission to transfer land is not automatic. The statute envisions that no such landholders shall transfer his land to any person who does not belong to a class of person as stipulated under section 160, except with the previous permission of the deputy commissioner, provided that in granting such permission, the deputy commissioner is required to have due regards to the interest of the people of the classes as notified under section 160 of the legislature. By incorporating this stringent provision sought to protect the interest of those protected classes. Any contravention of the provision of chapter 10 entails penalty under section 146B of the regulation. Next, Lordship, on perusal of the exhibit 8, it appears that the suit land falls under the tribal belt area even before the execution of exhibit 8, as it was mentioned therein that the land falls under the tribal belt and the vendor would execute a registered sale deed in favor of the purchaser after obtaining the due permission. Thus, as per exhibit 8 deed, the seller had imposed liability upon the himself to get the permission from the deputy commissioner for transfer of the suit land in favor of the late Sitaram Agarwala, the predecessor in interest of the plaintiff, who does not belong to the tribal class, but the plaintiff have failed to produce anything to show that such permission was obtained or granted in favor of the predecessor in interest to make the sale valid. As such, it can be held safely that the alleged sale of and possession of the plaintiff was not valid. This is the finding. Thus, when the sale of the suit land in favor of the predecessor of in interest of the plaintiff was not proved and the transfer was held illegal under the chapter 10 of the Assam Land and Revenue Regulation 1886, it can be held that the plaintiff have no right title and interest over the suit land. Further, from the evidence on record, it is already revealed that the plaintiff also had no possession over the suit land. In the result, this issue is decided in negative and in favor of the defendant.
When did the transfer take place?
1952, Lordship.
52.
Lordship.
According to you, this bar of transfer to non-tribals, when did it come?
I think by the amendment in 1964.
So earlier there was no bar at the time of transfer, although the land was within tribal belt. Is that your submission?
That is lordship.
So you are relying on guesswork. Yes, respondents.
Lord, Section 9 of the CPC are the trial by the civil court, which is barred by the special. I may kindly be allowed to read about the Section 9. Courts to try all civil suits unless barred. Section. The court shall, subject to the law provisions herein contained, have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly barred.
So under which section of the special act it is barred?
My lord, I may kindly be allowed to read the Section 167 of the Assam Land and Revenue Regulation. No civil court shall exercise jurisdiction in any of the matters covered by this chapter, that is, by the chapter 10. Chapter 10, bar of acquisition of in a belt or block, provided that no landlord shall transfer his land in a belt or block to any person not belonging to a class of people notified under Section 160. So, my lord, this land is admittedly situated.
Some land and revenue regulation.
No.
Assam. Yes, continue, please.
That the Sutland is admittedly situated within the tribal belt, and the tribal belt is created in the year 1947.
By notification?
Notification from. I don't know. I don't know.
Transfer took place in allegedly in 1952.
No, my lord. Tribal belt is special restrictions under Chapter 10 of the Land and Revenue Regulation. Prohibit transfer or sale of land in tribal belt and blocks from tribal protected class of non-tribals to non-protected persons. Original Assam Land and Revenue Regulation was enacted in 1886. Chapter 10 was added by the Assam Land and Revenue Regulation Amendment Act of 1947, and that is, it was inserted in 1947, creating the tribal belt. So since 1947, the tribal belt has come into existence. And the transfer of land under Section 160 of the Assam Land and Revenue Regulation is by the tribal to the non-tribal. And secondly, the
160.
160 of the Assam Land and Revenue.
And that bar is since when?
Since 1947, since the creation of the tribal belt.
Because it was the submission of your counterpart, that this bar came into existence only in the year 1964 by way of an amendment.
But that is not correct here. At 64, the registration of the cell deed is part. Strict provision is not by amendment. But there cannot be any registration of any cell deed since 1964 by the amendment. So, as a matter of fact, the land having been situated within the tribal belt, and this tribal belt was created in the year 1947, and by the provisions of section 160 of the Assam Land and Revenue Regulation, no land can be transferred.
All right, understood. This question would arise for consideration provided, suppose even if it is answered in favor of the second appellant, the finding on the other issue would remain unless they give rise to a substantial question of law.
Well, as per Transfer of Property Act, but there must be more, when the sale consideration would be more than 100 rupees, that must be affected by a registered sale deed. Although they have taken the plea that they have got the registered sale deed, but that sale deed was missing. When that sale deed was missing, they have not stated. They have also not made any attempt to call for the certified copy. They could not produce the certified copy. And thereafter, that my friend has submitted that an unregistered sale deed is made in the year 1952. But unregistered sale deed is inadmissible. How the sale deed can be admitted into evidence? So when a deed is to be registered, unless it is registered, that cannot be admitted into the evidence. They are saying it's not enough. And from the evidence, it also appears that they have not been able to prove the fact of their purchase. And as a matter of
So
fact,
the law on this point is settled otherwise. No new question of law has arisen, much less substantial question of law.
so there is substantial question of law is not there because the civil court cannot tie any suit concerning the declaration of right title interest over the plot of land existing in the tribal belt. Now, no court can declare the right title interest of any person which of the land which is now within the jurisdiction of the court, within the tribal belt. So, and the dispute in between a tribal and non-tribal. My lord, that the civil court has already barred the trial by the provision of section 167 of the Land and Revenue. So their plan is to declare right title interest. They are going to seek the shelter of the court for declaration of their right title interest on the basis of an unregistered deed. And that deed is also not admissible at all. Because the value as per the deed was 880 rupees of the total 4 acres land. Paid to have parcels at the price of rupees 880. So that deed is not at all admissible. So from that point also, they cannot prove their right of purchase. Then
Other issue.
His case is not at all. But provisions of the Assam ban and the. But section 9 of.
Lordship,
Yes.
other issue is that he established the possession, Lordship, by Exhibit 8.
But if the suit itself is barred, what is all that matter? Every finding may be in your favor, but if the suit itself is barred, how does that help you? Okay, we'll pass orders.
Like.
Chamber.
Wait, please, very much. Well, there are two appeals, my lord, filed by the same set of.
2004.
My lord. They have served us.
Even the name of the appellant has disappeared from the file. No longer visible.
In fact, my lord, I also did not have my file, my lord. I got it reconstituted, reconstructed. My lord, the respondent claimant have served us with a copy giving an information that the respondent claimant had died.
Come again, repeat.
They have served as a copy giving information that the respondent claimant had died. It's fine. So
So you
now
have
we
to
need to
implead.
substitute.
It is
There are
submitted
two
on
appeals.
behalf of the appellant that respondent counsel has informed about the death of respondent number.
One.
One.
In fact,
Whole.
no, my lord. There are two respondents.
Number one.
Second is the honor of the.
And hence, time is sought to file substitution petition. Accordingly, place the matter again on.
After 2 weeks.
2 weeks, yes, whole pending matter.
But may I pray one more thing, my lord? There are two appeals, my lord. Times filed by the same claimant.
Along with.
Along with 160 of 2004.
Is there along with?
Oblige. 160. 2004. Can it be 3 weeks, my lord? All right, my lord.
Please, your lordship.
Here in this case, my lord, respond number, so for the respond number 1, service is completed, appeared also, but for 2, we are asked to take face steps. We have taken face steps that the service not completed, my lord.
Complete service on respondent number 2
Ah.
is yet complete. Await service list again.
And a copy of memo of appeal may be served on us.
Copy of memo of appeal be served upon the
Service-
counsel for the
My
response.
lord, service steps was taken long back, my lord, 11/21.
Petitioner is at liberty to take fresh steps.
Yes, my lord.
Highly obliged.
May it please, dear lordship. Lordship, I'm paying for 1 week time, lordship.
Trying to do what?
Lordship, we are supposed to file some application.
Is prayed for by learned counsel for the appellant. Further 1 week time is granted to take appropriate steps. List again on.
Lordship, as per our last order dated 1/11/2025, you were directed to take steps upon respondent number 2 by usual process. So we have taken the step, but as per recent office note dated 27/2, as per recent office note dated 23/2/2026, AD card of respondent number 2 has not come back.
Third learned counsel, AD card in respect of R2 has not been received back yet as per office note dated 23/2/26. Hence, have it list again on.
Grateful.
Lordship, in this case, Lordship, I am recently engaged by the appellate Lordship. Recently engaged by the appellate Lordship. I've gone through the order sheet. Steps need to be taken upon the respondent number 2 and 3. May I prepare for 1 week time?
You are for?
I'm for R1, respondent one. For last 2 years, most probably no steps,
Even
no
the-
representation.
Even the councils were not there, Lordship. That's the reason I'm praying for 1 week time to take steps upon the respondent number 2 and 3.
Your name is reflected already.
Yes, now reflected.
Mr. S. Chakraborty learned counsel submits that he has been newly engaged by the appellant and seeks 1 week's time to take steps as directed earlier. Hence, list the matter again on. We did.
I'm for the appellate matter. And the advocate Tidip Kolita has appeared for the respondent insurance company. And also today, Sonali where she informed me that she has appeared for the owner, my lord. Case record, case record have not come, my lord. So
Third learned counsel for the appellant. None appears for the respondents, although they had already entered appearance. Full stop. Call for the TCR. List again on. Pencil for orders.
Case record may be called for.
Yes, TCR means case record.
Item 19. Let's say paper publication was made upon the respondent number 5 and 6. Accordingly, affidavit was filed. And now service is complete. Affidavit.
Third learned counsel. You're Mr. K.K. Bhatto.
Yes.
Bhatto. Learned counsel for the applicant and Mr. A. Acharya, representing respondents number 1 to 4. Para pursuant to order dated 11/11/25. The appellant has caused paper publication. You have submitted affidavit.
Yes.
And accordingly submitted the affidavits with along with the newspapers containing the aforesaid publication. Hence, the service on respondent number 5 and 6 seem to be complete. TCR received. TCR has also been received. Hence, list the matter for hearing.
Item 21.
My pleasure, Your Lordship. My lord, in this case, we made a paper publication for respondent number for service of notice upon respondent number 11, 13, 17, 18, 20, and 22 to 25, my lord. And we have filed an affidavit on 21, 2026.
Paper publication
Made, already made, and we
Made.
file an affidavit, my lord.
heard Mr.
SK Chakraborty.
Learned counsel for the appellant. You are for respondent.
I'm for respondent number 4142, respondent 43, for respondent 527, respondent 8 to 10, and respondent
It
40.
appears that by order dated 5/12/25, appellant was directed to issue notice to the respondents numbers 11, 13, 17, 18, 20, 22, 24, and 25 by in substituted mode by publishing the notice in 2 newspapers. Full stop. Affidavit has been submitted on behalf of the appellants stating that paper publication has been caused. Which paper?
My lord, Northeast Express and Dainik Navavarta Prasang.
The naam likhi dibo in the. Say again.
Dainik Navavarta and Northeast Express.
Copies of the. Where is the paper cutting? If paper is there,
Yes, yes, my lord.
copies of the newspapers have also been furnished along with the affidavit. Hence, service is deemed to be complete on the aforesaid respondents number. Kita di dibo eke number kita. Order dated 22/1/26. বাইশ তারিখৰ 22 অৰ্ডাৰটোত চালে নম্বৰ কেইটা পাই যাব। However, none appears for the said respondents. TCR is received?
Yes, ma'am.
TCR as called for has already been received. Hence, release the matter for hearing. On
After view vacation.
Also, I'm appealing for respondent for 2 and 3.
May please, Your Lordship. I am for appellant, Lordship. As per office note, that is 22/26, Lordship. Respondent number 1 has not complete, Lordship. Service is not complete. So today I am praying for press step as well as usual process along with the dusty mode, Lordship.
service on
Number 1, madam.
notice on respondent number 1 has been received back with postal remark, quote, not known, comma, return to sender. And processor first remark is that fixed date has expired and hence the same could not be served. It is appellant to take fresh steps, including by way of dusty service. Is the matter again on?
Oblige here.
Item 25. In this case, I am paying extension of time for paper publication upon the respondent number 2 and 3 and 4 and 5. That's it.
Our respondent number 1 also.
1 month time is required also.
Learned counsel for the appellant, stroke applicant. Mr. So and so appears for respondent number 1. Andy Bhuya.
S to sub. S to sub. Appearing on behalf of Andy Bhuya. Yes. Sub PUSN.
As prayed for by learned counsel for the appellant. 4 weeks further time is granted to first paper publication. Pursuant to order dated 24/9/2025. List the matter again on.
I am appearing for the respondent of 5, 10, 12 and 13.
No, Mr. Yes.
Number 5, 10, 12 and 13. ETL.
Respondent 5. Maybe if there
5, that means 5 has already appeared.
Yes, Your Honor. In last occasion, I have appeared, Your Honor. My name is shown in the.
So who remains for service?
3 and 4, Lordship. 2, 3 and 4. We have to take
2, 3 and 4 is the.
Learned counsel so and so appears for respondent number 4 and 5.
Company name. SC is abolished.
Therefore, only 5.
No, my lord, I am 5, 10, 12 and 13.
5, 10, 12 and 13. Hence notice is required to be published only in respect of respondent's number.
Lordship. I think that he is not appearing in this case, Lordship.
25.
No, sir.
25.
He is not appearing, Lordship.
বাকীখিনি কালি তলৰখিনি আগৰখিনি থাকক তলৰখিনি so appears for a yes.
All right.
Item 26.
None appears for the appellant or as per office note dated 29/8/24 is issued to the respondent number 3 was returned due to insufficient address and no ID card or unserved notice was received in respect of respondent numbers 1 and 2. And no affidavit of dusty service has also been submitted by the appellant, despite orders having been passed in this regard. And that no steps have been received by the section respect of pro forma respondents number 4 to 7 till date. Subsequently, by order dated 02/09/2024, appellant was directed to take steps upon the respondents number 1, 2, and 3 by obtaining necessary instructions with respect of the address of the respondent number 3, also to file affidavit of service of notice on the respondents by Dusty Mode. However, it's not dated 20/02/2026 indicates that steps have been taken by the appellant as directed by the previous orders. And today, none appears for the appellant on call. Although name of learned counsel has been shown in the cause list. Hence, the appeal stands dismissed for non-prosecution. Consequent, I also stands dismissed. View of order.
Make it your. Now the matter is before the executing court, my lord. My lord, yesterday only I could get some time and have found that even during the first title appeal, one order was passed by the appellate court, additional district judge, my lord, on 7/9/2012. Here also he did not receive the notice because the order is as follows. This both sides are present through their learned advocates. The appellant has filed a petition number 760/12, wherein it has been stated that repeated efforts to serve notice upon performer respondents other than performer respondent number 4, 5, and 7, who were expired, have been unsuccessful. It is further stated that the performer respondents have not contested the original suit. As well as in the said facts and circumstances, the appellant prays the name of the performer respondent 4 to 20, except 4, 5, and 7, be struck off to expedite the hearing. So, my lord, on that occasion also, during your appeal, that title appeal, this petitioner has not got the notice from the title appeal. Now, next comes, my lord, the second appeal. In the second appeal, what happened? Because who was the advocate? They have no idea, my lord. Nothing has been received. This petitioner has, my lord, 1 bigger 2 kotha of land. This sale deed, registered sale deed, it is not challenging the title suit, my lord. Because in 2000, in the year 2000, this, my lord, plot of land was purchased 1 bigger 2 kotha land in patta number 89, dag number 77 of Haidu, so and so, my lord, on 10/3/2000. The registered sale deed. This was not challenged, and this defendant, particular defendant, was made defendant number 4A subsequently, as because he wants to, my lord, encroach this plot of land, whereas he has a registered sale deed, my lord. So, my lord, again, now at this time of execution, my lord, others are not suffering anything, my lord. Only this petitioner, this 1 bigger 2 kotha land. Therefore, my lord, this petition, which was, my lord, this petitioner filed for sending their, my lord, thumb impression to the FSL, whether it is real or not. This petition rejection order was not just and proper, my lord, for the executive court, because my lord, this executive under order 20, yes, order 21 rule
26 also, this court has the power to stay the proceeding also. The court could have, my lord, examined this issue. At that time also, this could have been, my lord, verified whether they actually appeared or not. So, my lord, my humble submission is this, my lord, because this appellate court, as your lordship has already pointed out, rightly, my lord, there is no much power to revert the judgment and everything, my lord. So, my lord, my humble prayer is this, my lord, if your lordship gives some liberty to this petitioner to file appropriate petition to the appropriate court below, then I think they will get justice, because this period has already gone. But they will lose their 1 bigha 2 kata land, my lord, without getting any opportunity of being heard, my lord. It's very painful. Therefore, my lord, if your lordship pass any order giving some, my lord, liberty, that I think, my lord, at this stage they will get justice, my lord. And lordship, your lordship has given the executing court, power of executing court, my lord, your lordship I have gone through several judgments, my lord, but now to revert the judgment, in fact, has no power. So,
Okay,
lord,
instead of commenting on the merits,
yes,
we can simply say that he will file, if so advised, he can file appropriate application, which shall be disposed of as per law.
with liberty, my lord.
Liberty what?
Because liberty, this time to withdraw and to file appropriate petition, because this time already gone, my lord. This honorable court has stayed the proceeding since, my lord, filing of this CRP, my lord. Honorable Mr. Justice, my lord, first, I have all the, your lordship gone through the record of the case, my lord, stayed the proceeding since, my lord, first, this petition was served upon the respondents, then they appeared, my lord.
Proceeding means this is an execution proceeding.
Yes,
is
yes,
it?
my lord. This is the main thing.
Yes,
Because
that
my
has
lord,
been stayed.
yes, yes. Because they did not get any receipt except this, my lord. Except this. They were neighbor, my lord. They were neighbor. They are residing in the same locality. He has the, my lord, sale deed. Registered sale deed, my lord. Original sale deed is with him, my lord. Thereafter, my lord, without serving any notice, my lord, if somebody else has appeared and filed vakalatnama and with him thumb impression, which is not his thumb impression. So, my lord, without getting any opportunity of being heard, my lord, this judgment was and decree was passed. My lord.
So what application do you intend to file now before the court?
Before the trial court, my lord, because they have already filed one petition under Order 21, Rule 97. Now, that was before the executing court, my lord. That is page 28. The other side also, my lord, have filed objection to that. Defendant number 4A means, my lord, he was subsequently added as a defendant, and my lord, service, my lord, was not complete. Because on his behalf, somebody appeared, even in the title appeal also, somebody else has, my lord, oh no, this honorable appellate court also, my lord, that order, my lord, without serving any notice, proper notice today. In fact, he is a main, although he was made proper respondent, he is a main respondent, he is suffering, my lord. Other plaintiff, other defendants, my lord, has nothing to do. They are not approaching any.
All right, then we'll just we'll dispose
Yes.
this off with liberty to file appropriate applications. All right. But
Here, one problem is there, Lordship. Before learned executing court, one application
is pending. That is under order 21, rule 97 and 98. And as of now, they are going to challenge your honor expertise order. Suit is of 2000. Judgment and decree was passed trial court lordship 2008. Then first appellate court affirmed that judgment in the year 2014. Honorable Gauhati High Court in regular second appeal, that was again dismissed second appeal in the year 2016. Now application under order 21, rule 97 and 98 is pending before executing court. And where they filed another application, that is on the order 26, rule 10A. This is your honor interlocutory proceeding against an application filed before learned executing court. Ultimately, they are challenging.
We are not deciding. We are not deciding anything here.
Ultimately, your
It is
honor,
for the court to decide. If in the event any application is filed, it is for the court to decide. That is all.
ultimately, they
You can't stop anybody from filing any application. Anybody can
going
file any application. It is for the court.
that liberty will impact in further.
How will it
proceeding.
impact in the decision? We'll say court will dispose as per law.
Otherwise, lordship, they are going to challenge expertise or judgment and decree, which was passed in the year 2008. 24 April 2008.
Subsequently, there was appeal, I think.
Ultimately, they will have to challenge first order trial passed by trial court.
Yes.
After disposal of first appeal, second appeal, in execution, they wasted more than 8 years' time.
No, my lord,
Now,
without
in a-
notice, how
in
I
a-
can come to know that
in a-
one suit is pending?
In an interlocutory application, if they get opportunity,
This petitioner had
with
no knowledge.
liberty to challenge the order passed way back in the year 2018. 8. Otherwise, my party is waiting to get the fruit in execution proceeding since 2014 lawsuit.
One FIR was also lost. These things are there, my lord. Why liberty is not, if your lordship do not give any liberty? Because then, my lord, this period, without receiving notice, had I been received any notice, then the matter would have been different, my lord. Without knowledge, till execution notice is received, my lord. So this period, entirely, my lord, without any knowledge. So this period is not countable, 2008 or 2000, whatever it may be. But I have a sale deed, this is a registered sale deed of 2000 prior to filing of the suit, my lord. They have not challenged that. It's a public document. They have not
No,
challenged
we'll
that.
not go into those facts.
Therefore,
We will,
Lordship, withdraw the petition pending before executing court under order 21, rule 20.
They will decide, my lord, whatever
This is
they.
interlocutory, lordship. Your main case is pending before executing court, questioning wrong service of shaman.
no, this application you are talking about, that is, where has that been filed? Not before the executing court.
That is executing court. That is
Yes.
still pending, untouched. After filing this.
So once this is withdrawn, that will resume.
Yes, yes, my lord.
Once we dispose of
Their
this,
intention is to file a separate proceeding. Whereas that order 21, rule 97 and 98 is pending. Lordship knows very well, as per principle of order 21. Order 21, rule 97 and 98 is also proceeded like a suit. So during pendency of this application, Your Honor, so if they file another application on same contents, that will attract a res judicata lordship. So allowing them with a liberty to file order 9 application.
if they file an application which is substantially the same as the one already pending,
Yes.
then law will take its own course.
Yes, yes, my lord.
That it is not maintainable.
It's a lawyer code. Definitely.
No, my lord, it's not the thing. my
All
lord.
right, we'll say like this. Third learned, Mr. Learned Counsel for the petitioner and Mr. Prayer has been made to permit the petitioner to withdraw the petition with liberty to file appropriate application before the learned executing court. Learned counsel for the respondent has submitted that there already is pending an application under 97
Under order 21, rule
21,
97 and
97,
98.
98.
Rule 97 and 98 CPC. And therefore, there is no scope for filing any further application on the same subject and for the same reliefs. Regard to the above, the instant civil revision petition is disposed of with the observation that in the event the petitioner herein took JD submits any application before the learned trial executing court.
Appropriate court. Well, it will be better to appropriate court.
First, it is before appropriate court, a different court than this 97 that will not come. That will be considered by the court in its own merits.
Yes.
We will not say appropriate court, we will say executing court only. The then shall be considered by the learned executing court in conjunction with the applications under order 21, rule 97 and 98. Dispose of the same accordingly. In the event the petitioner seeks to put any other suit application before any other court, that is a matter for the state court to consider, and the present this revisionary court did not make any comment on the same. Repeat the petition stands. This was the accordingly.
Maybe vacated.
Stay order passed earlier stands vacated.
Obliged.
May I please, Your Lordship? Lordship, as per office note dated 23/2026, LCR has been received. Service.
All have appeared. Respondents are represented.
Yes, Lordship.
Learned counsel for both sides. LCR has been received. List the matter for hearing. On? Is it admitted already?
Yes, Lordship.
Already. The matter for hearing on.
Obliged, Lordship.
And none appears for the appellant on call. Thus, learned counsel has appeared on behalf of respondents number 5, 10, 11, and 12. As per office note dated 20/02/26. Learned advocates have entered appearance on behalf of respondents number 1 and 2. But unserved notices have been received in respect of pro forma respondents 4, 7, and 9. But AD cards or unserved notices have not been received back. Respect of pro forma respondents 6 and 7. Appellant is directed to take press steps on the pro forma respondents number 3, 4, 7, and 9 after ascertaining their proper address. Is the matter again on
My pleasure, sir. Here also respondent number 2 died, lot, and he is dead unmarried, lot. And his legal heir is already in party in this main appeal. And my humble prayer, respondent number 2 names may be strike out in the appeal memo. Because there his legal heirs are already in the party, lot.
submitted on behalf of the appellant that the respondent number 2 has already expired and the legal heirs of the said respondent number 2 are already parties in the present proceeding. Hence, the name of respondent number 2 is struck off. Post title be amended accordingly. PCR is received.
Yes, Lord said.
Here has also been received. The matter for hearing on.
Obliged, Lord.
31.
Well, here. Well, actually, this case, I filed a suit was dismissed. I will file after a delay of 6 months. That condemnation petition has been dismissed. And that is why I come this record. So record, both the record come. Any day needs to fix for.
Heard Mr. J. Ahmed, learned counsel for the appellant, and Mr. G. Bharadwaj.
disseminate, I am appearing for respondent all the respondent except 10 and 14 on behalf of
All the respondents
except 10 and 14.
except 10 and respondents 10 and 14. They have been represented.
My name is Nabik.
Item 31.
Yes.
14 struck out, madam.
14 strands.
10 and 14 struck out.
14 is struck out.
Eight 2022 order also can be seen.
The AC Sharma is there.
Yes.
List the matter before another bench without. It.
That may be given.
নালাগে LCR রিসিভ হয়ে গৈছে তো আৰ্লি ডেট দি দিয়া সিদিনা অৰ্ডাৰ পাছ কৰি দিওঁ
Mars. For hearing, huh?
In this case, I am appearing for respondent number 1, claimant receipt. So far as service is concerned, I think it's complete. Receipt kindly see the official dated 22/26. LCR has been received, receipt.
This is complete.
Who are respondents 2 and 3?
Owner and driver which.
Basically, they have challenged quantum only.
There is no dispute regarding liability of the insurance company.
No dispute.
Owner and not required.
Not required.
Then the notice was hanged in the house of the
It's
person.
there,
Service
there.
will be accepted.
Because hung means there was there any order for that?
Yes, sir. Office note that 22/2026.
No, there is no court order for that. Service by way of hanging. Okay. They can be struck off, I think.
What's
Huh?
if when in absence of the owner and driver of the vehicle, the appeal may be hard, because
Yes, that is what I'm saying. But KK Hotel Learned Counsel for the appellant insurance company. Sir, appearing for respondent number
1.
1. Submitted on behalf of the appellant that the names of the respondent numbers 2 and 3, owner and driver of the vehicles. Be struck off as the dispute is only with regard to the quantum and liability of the insurance company is not denied. Accordingly, the names of respondents number 2 and 3 are struck off. That will be corrected accordingly. List the matter for.
Now, LCR has been received. Now, see.
Here
Can
received.
be listed
Here has
for
been
hearing.
received. List the matter for hearing on.
April. Date may be fixed, now, see. Right, now, see.
His pilot TC are already received plan. So the matter will be.
There is ready as regards service as well as records, my lord, so can be fixed for hearing.
Third learned counsel for both parties. The matter is ready for hearing. Hence, is the matter for hearing on.
%20. Highly.
35.
Lordship, we have filed on I Lordship an application for withdrawal the amount which has been deposited. The entire amount has been deposited by the insurance company, awarded the entire amount with interest, Lordship. And we seek the permission for withdrawal the said amount because there is no permission order for withdrawal the payment of the respondent.
Objection to the withdrawal application.
Also on record.
There is no any merit lordship. They have filed a appeal lordship for recovery the amount lordship. Already that recovery part is already there in the trial court order lordship. So on the basis of that order lordship, that this court has already given direction to deposit the entire amount for that reason. Already recovery order is there. In the main appeal also point filed for appeal for only recovery lordship because driving license was fake at the time of accident lordship. Already all findings is there lordship. Not arise for permitting the withdrawal the amount lordship.
Lordship, our ground of appeal is that it's responsibility to pay and we should not be made to pay the first instance. After this amendment, pay and recovery has been removed. So we have filed an objection. Service is also complete and LCA has been received.
So you withdraw 50% now.
Whole amount has been.
Suppose you withdraw the whole amount.
Yes.
And the appeal goes in their favor.
No, no lordship. The appeal ground is lordship kindly see the ground of the appeal lordship with in the ground of the appeal 5 lordship. They seek the recovery from the owner lordship after payment. After payment, they seek the recovery of payment.
That is the challenge is not on merits.
Not lordship. Only recovery of payment. Already recovery of payment order is already the trial court order also reflected. The recovery amount compensation from the insured if they desire.
Where is the appeal?
Lordship, the owner has not filed the wakalatnama, he is not appearing.
Where is the appeal?
That is not a ground lordship.
Courtmaster.
They have not seeks any other defense lordship. They only seek defense for recovery the awarded amount from the owner and insured. Already owner and insured, already that order is on the trial court order also dear lordship. Lordship kindly see the ground number 5. Their appeal lordship.
Connected appeal refund आए है.
Appeal. Was only the ground of the driving license lordship. Kindly see the ground of their memo of appeal lordship, ground number 5 lordship. Ground number 5 lordship. For that the impugned judgment and award is bad in law and liable to be suitably modified in view of the current decision of apex court, giving liberty to appellant insurer to pay and then recover the awarded amount from the owner and insured of the vehicle lordship. And lordship, again lordship, see the trial court judgment lordship. Trial court judgment lordship, internal page number 8 lordship. So nothing is more lordship, only recover the pay and recover the amount from the owner lordship. For that reason lordship, this court has given direction to deposit the entire amount lordship with interest lordship. Accordingly, they follow the order and deposited the entire amount lordship. Lordship kindly see the internal page of trial court judgment lordship, internal page 8 lordship. From top lordship, party number 2 is held liable to pay compensation to the claimant. However, the insurance company shall be liberty to recover the amount compensation from the insured if it desired. Already that part is there, lordship.
Appeal was needless actually.
Yes, lordship. And for that reason, lordship, this court has passed order the entire amount deposit with interest, lordship. Kindly see the annexure in my lordship, annexure number 1, lordship, kindly to give direction of the last order of this court lordship. Order of this court lordship. To shall remain suspended and subject to deposit the entire awarded amount with interest with the registry of this court within 6 weeks, lordship. That is the order of this court lordship. Appeal is needless, lordship. Already the parties, dear lordship, they have filed appeal, lordship.
We heard learned counsel for the applicant stroke respondent in the appeal. Also heard learned counsel for the insurance company. This IA has been referred seeking to withdraw the awarded amount along with interest which has been deposited by the insurance company with the registry of this court pursuant to order. Which order? Order dated this court's order directing deposit.
5/6/2017, lordship.
Dated 6.
2017, lordship.
5/6.
Yes, lordship.
5/6/2007. In IA civil number 1754 of 2017. Action has been.
Lordship 2025, lordship. 1700/2025.
That is the order passed in
Yes,
on
lordship.
5/6/17.
Yes, yes.
You have stated 1754 of 2017.
Yes, sir.
Okay, check that one, which is the 17, like yes, 25.
No.
Right.
1754 is 17, that is their IA, lordship. Now we seek withdrawal of the.
No, I am asking by which order was the insurance company asked to deposit?
Yes, lordship. 1754/17, lordship.
Dated 5/7/2017. Passed in IA 1754 of 2017, the lordship.
So what are we saying now? That is what we are saying.
Yes, yes, lordship. Sorry, lordship.
An objection been filed on behalf of the insurance company. Stating that there are strong and cogent grounds in the appeal. For its success, and in the event of release of the amount, the insurance company will suffer irreparable harm of a perusal of the bills that it has been stated. That the impugned judgment and award is bad in law, is liable to be modified. Liberty to the appellant insurer to pay and then recover the awarded amount from the owner stroke insured of the vehicle. The above, it is clear that there is no substance to the objection filed by the insurance company. Therefore, withdrawal is allowed. The claimant stroke applicant stroke respondent in the appeal is permitted to withdraw the entire amount deposited by the insurance company from the registry of the court, subject to execution of suitable bond. I stands disposed of. In the main appeal, you write. TCR is received.
Sir, Lordship.
The TCR is
Service is also complete.
received and service is also complete. List the appeal for hearing on.
First week of April. Yes.
Awesome.
Five missed cases, 6 missed cases, my lord. That all the, appellant response has been died. And last, my lord, first missed case, my lord, that was filed on, my lord. 19/9/2025. The respondent has informed that I give it to me. The respondent died on 3/3/2021.
So substitution is required.
Yeah, I filed subject to I filed an application, my lord, on 19/3/2025. Personal legal years. They inform me on 22/8/2025, and we have filed on 19/9/2025, my lord.
In IA 3306, my lord, we have no objection. That may be allowed.
The other, my lord, 5 missed
No,
cases
first-
there, my lord.
First, this has to be allowed, my lord.
IA?
IA, my lord.
3306.
3306. All right.
25.
Sole respondent died.
Third learned counsel for the petitioner, as respondent. This application has been filed seeking substitution
Of the sole respondent, my lord.
of the sole respondent Manik Chandra Ghosh
Yes, my lord.
by his legal heirs. Who are stated to be as follows.
Babal Ghosh, Dhruvrajyoti Ghosh, Vidhan Ghosh, ঠিক আছে নাম না? ঠিক আছে।
You'll find in the cost title. Okay, page 4. English, the state legal heirs stand substituted in place of the deceased sole respondent. Very application for amendment of the cost title be submitted to the registry. I stands disposed of accordingly. Next.
The other missed cases, my lord, they
My
have
lord,
to-
other missed cases has to be after the amended, the cost title,
Alright.
because sole respondent died, there is no body on record.
Is the matter again? Later did it?
Item 38.
Lordship, it's an application under order room group 10 for impleading two son of the deceased claimant number 2, who was not made party in the appeal because he died after hearing of the argument before passing of the judgment. His name is appearing in the award.
What is his name?
His,
Who died deceased?
This is name is Lohit Chandra Das. It is at page number, Your Lordship, 8 of the appeal.
It had learned counsel for the applicant. An applicant and learned counsel for the insurance company. An application seeking Treatment of the legal heirs of late Rohit Chandra Das.
Yes, yes. Rohit Chandra Das.
Expired on 17/10/2016, leaving behind the following legal heirs. Find it paragraph 3, okay? For the respondent has no substitution. Aforesaid legal heirs of the deceased Rohit Chandra Das are implicated as respondents number. They will be
It will be appellant number 2 and 3. They will be appellant number
2A and 2
and 3. One is already there. Two. They will be 2 and 3.
and 3. This Subala Das.
She is already there. She is mother.
She is already there. Okay. 2 are required. Okay, 1 and 2 serial number at paragraph 3.
Present petitioner, you know.
Stands disposed of accordingly.
I will submit cause and title to the officer, and accordingly they will. Your Lordship, the matter was already in hearing list, Your Lordship. So after that, it may come for hearing.
The appeal you write in view of order passed in the connected IA is the matter for hearing after correction of the cause title. On the date.
In March any date. Yeah.
In the month of March.
Lordship, in this case, I am appearing on behalf of OP number 1 to 5. The copy served by the petitioner in delay petition, they have not mentioned the number of, they have not mentioned how many days of delay was caused. So they may be directed to supply fresh copy to us, mentioning the days of delay. And we are also going to file objection against the delay condemnation petition.
Please, Your Lordship, matter today matter is come up for first time, Lordship.
Yes, matter is first time, but we have not mentioned the number days of delay in your delay petition.
But anyway, you have to file objection.
Yeah, you have to file objection.
With
Days of delay
counsel
not
for the applicant and learned counsel for the respondent number
1 to 5.
1 to 5.
Please, Lordship, total respondent number 7, Lordship.
Issue notice to the respondent number 6 and 7. Petitioner to take steps by speed post with AD. It is submitted that the number of days of delay has not been mentioned. But we'll just say to serve extra copies. That's all.
They can just mention how many days were delayed.
They say 113 days.
113 days, Lordship.
113.
100.
So you note that down. That we will not record all this. All right. Please place the matter again on so and so. Present respondents may file objection. In the meantime.
Okay.
Obligation.
May it please, Your Lordship. Lordship, as per office note dated 24/2/26, respondent number 1 has entered appearance. And respondent number 2 and 3 were struck off as per court order dated 13/2/26, Lordship. There is a delay of 15 days, Lordship.
Third, Thames Oikea Learned Counsel for applicant. As per office note dated 24/2/26, advocates have entered appearance on behalf of respondent number 1 by filing wakalatnama, and names are also reflected cause list. But none appears on call. This is an application. Explanation of delay of
15 days, Lordship.
15 days in preferring the connected appeal. Para having regard to the averments made in the instant application with regard to the cause of delay supported by an affidavit. I am of the view that the applicant was prevented by sufficient cause from referring the appeal within the period of limitation. Accordingly, the delay stands condoned. The IA stands disposed of. The main registry to the connected appeal is accordingly.
Obliged, Lordship.
Please, Lordship. The matter, the appeal was settled in Lok Adalat at an amount of rupees 6,50,000. There was a further direction that if the said amount is not paid within 45 days, they'll have to pay interest at the rate of 7% per annum from the date of filing of the claim petition. But they have deposited the amount after 87 days. So insurance company is liable to pay the interest amount. They have
In
deposited.
this case, no, I am not in this case, Lordship. Maybe you should, Lordship.
Copy served on him. Lordship. In the appeal, he appeared.
It was served to my clerk, Lordship, not to me, Lordship. I am not in this case. You should, it is the knowledge of the company, whether they have deposited within.
Third learned counsel for the applicant issue notice to the respondent. Steps by registered post, speed post AD on the respondents within 3 days. Again, for each of them.
So in this case, my lord, lordships were kind enough to grant me, my lords, the dearest bail. And the bail petition was disposed of, directing me to, my lord, seek regular bail within a period of 15 days. Lord, that was done on account of the submission of learned PP that the charge sheet has been submitted way back in December, my lords. Now, the difficulty is, my lord, that when we went there to file the bail petition, my lord, the charge sheet has been submitted, that is the correct, my lord, but the matter has not been committed by the court of the learned magistrate, my lord, to the court of the learned session judge Dibrugarh. Because in that view of the matter,
Because you have not appeared.
no, my lord, cognizance has not been taken. The matter has to be committed, my lords, because there are other accused. There is another accused in this case also. There are two accused, and my lords, the other accused is also on interim pre-arrest bail now. My lord, the protection that was granted to me, my lord, that has become, my lord, the structure, because I cannot approach, because lordship has said, my lord, learned trial court. Now the learned trial court in this matter, it's a session tribal case, my lord, would be the learned session judge. Learned magistrate would not be in a position, my lord, to grant me bail. But my humble submission was that perhaps this order of bail can be extended. The stage of cognizance, because the learned session judge has to take cognizance of the matter.
We want extension of the time.
Lordship. Because now I am in somewhere in between. I cannot go to the learned magistrate, I cannot go to the session court.
Heard learned counsel for the petitioner. This application has been filed seeking extension of the time granted by this court by order dated
Page 8.
070226 in AB 2733 of 25 for appearing before the learned trial court, which was 15 days. It is submitted on behalf of the petitioner that although the charge sheet has been filed, cognizance has yet to be taken and the matter has not yet been therefore committed the learned trial court, which is the Court of Sessions. Therefore, the petitioner appear before the learned trial court at this point of time. What will happen with the extension?
Lordship will protect me till the learned session judge take cognizance, issues the summons, because otherwise the fact remains that now that the charge sheet has been filed, the need for custodial detention is no longer there. Perhaps I could even pray that your Lordship enlarge me on bail till the end of the trial, because that is normally how things are done, unless there are special reasons. But now in this case, there is nothing to show. There is any violation, Lordship will impose strict conditions.
Aspect that would have been done. In view of the aforesaid fact situation. Order of in pre-arrest bail is extended till committal of the case to sessions. But on if you without your appearance, how is it going to be committed?
But that precisely is the difficulty, because if that bail, if I go before the learned magistrate, the issue will arise, my lord. He cannot enlarge me on regular bail, my lord. It's a session tribal matter. I'll be put behind the bars. Let the case be committed, my lord, and the learned session judge will take cognizance. Well, because we have already appeared before the IO, also recorded statements, etc. All that was done after the interim order, after the interim bail order, my lord.
Now, has the charge sheet been filed showing you as an absconder?
No, my lord. In fact, in the charge sheet, my lord, it has been recorded that I have cooperated after your lordship's interim bail order. So it is recorded there. It is recorded in the charge sheet, my lord, that I have already cooperated with the Lord's police and I have recorded my statement also. So I am not an absconder and I cooperated, my lord.
You have received summons from the magistrate?
No.
Have not?
No. It was only because of the submission made, my lords, by the learned PP that the charge sheet has been submitted. Thereafter, your lordships perhaps were under the impression that I could apply for regular bail before the learned session judge, my lords. Since the matter has not been committed, so my lord, now I am, my lords, in a difficult situation.
Let it remain that way, then petition stands disposed of. Any kilo. Orders or key again?
Lordships have made this order absolute.
Absolute, we have extended it
in the stage of committal. All right.
What key is it?
If we have taken the steps on 26/2/2020.
Learned counsel for the appellant submits that steps have been taken for service of notice on
26/2/2020.
26/2/26. Hence, await service. List again on.
Item 49.
Yes.
So I postponed, they have filed another petition, rejoinder petition has come it or not filed. 49.
Maybe I have filed objection that has come, lordship.
Change it police আপনি changed হয়ে গেছে. They have changed one page most probably that has come on recording.
What is the matter about?
9th or 10th. This is for only for release of the insurance amount deposited by them, lordship. My IA is for that purpose.
But learned counsel for the applicant as well as respond. Objection has been filed by the. Is the matter again on?
8th, 9th, lordship possibly.
Okay. 9 is holiday.
9.
9.
9
Okay.
is working day. Okay, 9th must be working day.
45.
Lordship, 45, it is wrongly shown in hearing column, Lordship. Actually, in the last order dated 18/2, it was shown that respondent number 1 has expired and respondent number 1 advocate was to give us details of his date.
You are for the?
For the respondent number 1. Lordship, sorry, respondent number 2.
None appears for the appellant. Third learned counsel for respondent number 2.
Sorry, Lordship, I'm for the appellant.
Third learned counsel for the appellant. None appears for the respondent. By order dated 18/02/26. Learned counsel for respondent number 1 was asked to furnish details regarding the death of the deceased respondent number 1, but none appears. Is the matter again on?